everybody, this is our Katie Frekhtman, a New York City personal injury trial attorney, and today we're talking about spinal fusions, both cervical in the neck as well as lumbar in the lower back, and they are back surgeries, spinal surgeries. So today I wanted to talk about a few different cases in New York, recent cases about spinal fusions, and I believe when we did our segment the last week tonight, a lot of people asked about this and they wanted to know more about spinal fusions and have case examples. So let's get started. I actually ran two different searches using those platforms like LexisNexis and Westlaw, where you could research past cases and do like a verdict search. So I ran two different searches. One was just for spinal fusions. And so that includes any kind of spinal fusion case, right? It could be a slip and fall, it could be a car crash, and it pretty much could even be a medical malpractice. And it covers the entire state of New York. And then the other search I did was for the same thing, for spinal fusions, but only bigger cases where the result was either 5 million or greater. So, you know, I have these two different lists, and actually it turned out to be pretty long. Like one of the lists is like 400 pages because I guess it just went back, you know, many years. But let's start. We'll do a few cases. We probably can't do, can't do all of them because there's hundreds of cases, but we could start and we could talk about starting from the big list. For example, here's a case from the Bronx. And, you know, one of the things I wanted to explain is that I think a lot of the past videos we've done where we talked about what determines value, and we talked about, for example, venue, we talked about the type of accident or the type of crash, the type of situation, you know, you could see from these cases what I've been telling you before, you know, is true, because like it tends to be that the more tougher venues like Staten Island, Long Island, Westchester are getting either defense verdicts, meaning the person got 0, or they're getting much lower verdicts. And you could see the more favorable verdicts like the Bronx are getting big numbers. So for example, here's a case from 2020, right before the pandemic. This was, I believe, a trial, March 19th of 2020, and it happened in the Bronx. And so it was a car crash. And what happened was that, okay, there was a motorist and a passenger, and they were both ladies, and they were driving a Toyota Corolla, and they got rear-ended by a Camry driven by the defendant while they were stopped. And what happened was their car was stopped for a red light, and it remained stopped after the light turned green because there was a pedestrian in the intersection, and so the defendant slammed them into the rear. And what happened was they had, well, one of them had cervical herniations that required fusion surgery. But that wasn't the only injury. There were a lot of other injuries. There was an asthma attack. There were right knee injuries with a knee surgery. There was aggravation of pre-existing injuries. And so they sued the guy who hit them. And the defendant denied their allegations, and the defendant said he was braking and traveling less than 5 miles per hour when his vehicle slid on black ice, and that's why the crash happened. And it said it was uncontrollable, and it was a very light impact. And then the defendant, through the insurance company and his or her lawyers, also contested the nature, cause, and extent of the plaintiff's claimed damages, noting plaintiffs had been injured in prior car crashes. And so partial summary judgment was granted to the plaintiffs, meaning the issue of liability partially was already given to the plaintiffs since it was a rear end and they were stopped. So the result was a verdict, and it actually came up as one of the plaintiffs. She received $150,000 for past pain and suffering, $75,000 for future pain and suffering, and $1.9 million for future medical expenses. Now, the other plaintiff received $300,000 for past pain and suffering, $3.2 million for future pain and suffering, $1.9 million for future medical expenses, very similar to the other plaintiff, and $82,000 for past lost wages. So the total verdict in this case was actually $7.7 million for both plaintiffs. So it was a pretty high verdict, you know, especially if it was like a 5 mile an hour little fender bender. That was a really good result. Okay, let's go to the next case. The next case happened also in the Bronx. And this was a premises liability case. What happened here was somebody was in their apartment and the ceiling collapsed on them. And they suffered spinal herniations, which required a spinal fusion surgery. And that caused permanent damage and will require future surgeries. It also caused a concussion. And it all happened when the bedroom ceiling collapsed. There was also a tear of the Achilles tendon and torn ligaments in the foot when the person jumped because they were surprised, they were startled, and slipped and fell on water debris next to the bed. So yeah, so basically they claimed a res ipsa loquitur theory, meaning the thing speaks for itself. You know, my ceiling in my bedroom shouldn't just collapse on my head. This is not something that happens absent negligence. So if that happens, that means my landlord was negligent, the management company was negligent. And so, let me see here. The plaintiff, the defendants argued they did not create or have any notice of the defective condition. They didn't know about this issue with the ceiling. And they also argued that, let me see, what the plaintiff was arguing with respect to notice was that, well, they argued that the defendants owned and operated the building. They argued the res ipsa theory. And they also, they just argued that they failed to properly maintain the ceiling after buying the building because they recently purchased the building, but they didn't maintain the ceiling. I guess they didn't do a proper inspection, proper maintenance. And actually they received a grant from the city, money from the city to renovate the building, but for whatever reason, they didn't do it. Maybe they pocketed the money and that made the jurors mad. It's hard to say because this is a very short summary. It's like a jury verdict report, so they give you a short one-paragraph summary. But yeah, the plaintiff contended that that she was eligible for damages, and they used the res ipsa. So the way that the case broke down was that the past pain and suffering, or actually, let's just say the way it's broken down here is just says compensatory pain and suffering. So I guess it includes both past and future, was $7 million. And then the compensatory future medical expenses were also $7 million. So the total verdict was $14 million. So a very, very good result here. And this case was also in the Bronx. And also, it was in 2019, the trial. So yeah, I have a Bronx office. I should go there more often. I should just do Bronx cases. This is crazy. These are great results. So let's go to the other list. Now, this is the same thing, right? Fusions, but this includes all the cases. So let's do one. Here's a case from Staten Island, also a premises liability case. What happened here was there was an office building and somebody fell. It was also a lady. She claimed that she had suffered cervical and lumbar bulging discs requiring an L5-S1 pedicle screw fixation and fusion, L5 nerve root injury, right rotator cuff tear requiring surgery, right forearm hematoma, left hip contusion. So she had a lot of injuries. What happened was she claimed that she slipped and fell on a slippery substance in the hallway of an office building where she worked. But it was owned and controlled by the defendant's shops at the Gardens and some other group. So she can't sue her employer, right? Because that would be workers' comp. But that wasn't her employer. I guess her employer was a tenant in the building. It was a big building, and she sued the owner and the manager of the building. And she claimed that the defendants were reckless and negligent in having a valve in the stairway with chemical solution and failing to have proper equipment in the stairway, failing to clean the area despite having notice because this valve, I guess, was leaking, and it was leaking for at least a day prior to her falling. And she argued that allowed a slippery condition to form and exist, and failing to warn people by putting like a yellow caution sign. So the defendants argued that they denied liability, and they said that the plaintiff was unable to identify the cause of her fall. So I guess she didn't know whether it was the valve leaking that caused her to fall as opposed to something else. And ultimately the jury reached a defense verdict. So they allowed for 0. They found that she did not prove that the defendants were negligent. So that was the case in Staten Island. And then we have a case in Nassau, which is also a conservative venue in Long Island. And what happened here, there was a parking lot crash. And a lady claimed multi-level cervical herniation, cervical radiculopathy. That's the traveling pain from the neck down to the arms. requiring a fusion surgery, a right knee meniscal tear, cervical and lumbar sprains, disc bulges in the C6, C7, right shoulder impingement. So she had a lot of injuries, and she drove through a parking lot. Her vehicle was struck on the front right by somebody pulling out of a space, and it was actually a defendant who worked as a valet for the parking company. But the defendant argued, and the plaintiff, let me start with the plaintiff. The plaintiff alleged that the defendant was negligent in failing to operate the vehicle in a safe and prudent manner, pulling out into her, and he was actually working there, so he should be careful. He was a valet in the parking garage. But what the defendant said was he disputed the liability, and he argued that the plaintiff was negligent in driving on the wrong side of a median and on the left side of the aisle right next to where the valet parked vehicles were. And he said because she did that, it precluded him from avoiding the collision because he didn't expect anybody to be there, right? And the jury agreed, and they found the defendant was not negligent. And so the result was 0. So yeah, it really runs the gamut. Here's another one with a labor law case or construction accident case. Here, what happened was it was a case out in, let me see, it was also actually a lady, and she suffered permanent disabling injuries, including herniated discs in her neck and her cervical spine, and a 3-level cervical discectomy and fusion, a left rotator cuff impingement syndrome. She suffered 39.5% loss of use of her left arm, chronic headaches, chronic pain, loss of motion and strength. So again, very, very serious injuries. What happened here was a ladder fell on her as she worked as a laborer on a construction project owned and controlled by the defendants. I guess it's the landlord of the construction site as well as the general contractor. And she argued that the defendants created an unsafe and dangerous condition by placing an unsecured ladder in her work area, by failing to provide any devices to secure the ladder, and in causing it to fall and strike her. And the court granted summary judgment on the issue of liability in favor of the plaintiff, because in New York we have a labor law that protects the injured construction worker, especially if it's gravity related, if it's a falling object or a falling worker. Here, the ladder fell, it was not secured, and so it's a falling object that was being used in the construction. Obviously, a ladder is being used to do the construction. So the only issue were her damages, and the jury found that the pain and suffering was $1.5 million, past medical was $41,000, future medical was $261,000, past wages were $163,000, future wages were $356,000, so the total compensatory amount was $2.3 million. And that was a case where, yeah, the verdict was $2.3 million, and the case was in Erie County. So it was upstate Erie. I'm not too familiar with that, but that's way upstate New York. But that was, a pretty good result. Compared to some of the others which people are getting 0. So here's I'll do one or two more cases. Here's a case where another construction case where it was a plaintiff's verdict. It happened in Brooklyn, in Kings County, which is Brooklyn. And it was a work accident. What happened was a plaintiff, a male construction worker, was allegedly, he suffered multiple bulging and herniated discs, and he had spinal fusion surgery. He also had other injuries like chronic pain, permanent limitation of spinal and extremity function, radiculopathy, inability to work after the incident. And what happened was he was removing molds from a previously poured concrete wall. And it happened at a job site owned by a general contractor defendant and a landlord, a property owner defendant. Remember, general contractors and landlords are strictly liable under the labor law. So what happened here was he was bending over near a 15-foot aluminum ladder propped against the wall under which plywood had been placed by a co-worker. He stepped on the plywood, causing the ladder to slide off the wall and strike his back, and that's what caused the injury. And he basically claimed labor law 200, 240, 241.6, by failing to provide a safe place to work, allowing dangerous work conditions to exist, failing to provide proper and safe tools, as well as failing to supervise and inspect construction activities and prevent an improperly secured ladder to be and remain on the premises. And the damages were disputed, but the jurors allowed for, now, pain and suffering, $17 million, past wages, $222,000, future wages, $1.8 million, and the total compensatory amount was $19 million. So a very, very good result. It doesn't say what happened on appeal because these are just the verdict searches. I don't know if that was sustained or if it was reduced, but it says here, it says here that the medical expenses included the cost of physical therapy, past medical and medically related expenses, and there was more than $2 million for past and future lost wages, loss of earnings. So that's a very, very good result. And let's do maybe like one or two more. Here's a case, an interesting case involving Dram Shop. And this was a case also, I believe it was a little bit upstate. Dram Shop, by the way, is when you sue like a bar or a restaurant and you claim that, hey, you are serving somebody who is already visibly intoxicated. So if somebody has, let's say, 2 or 3 shots of vodka and they're visibly intoxicated and they're stammering, they can't stand up straight, and then the bar goes ahead and serves them more alcohol. Now that guy goes outside to the parking lot, gets in his car, drives, kills somebody or hurts somebody, the bar could be liable under the Dram Shop law. So this was a Dram Shop case, and an adult male sustained injuries, C4, C6 disc herniations leading to cervical radiculopathy, requiring a C4, C6 cervical discectomy infusion and bilateral nerve block injections, as well as chronic post-traumatic occipital neuralgia headaches, bilateral carpal tunnel syndrome, so other injuries as well. But what happened, he was legally parked and he got struck by an intoxicated driver. The defendant, who was an employee of a tavern owned and operated by defendant. And so the plaintiff contended that the defendant driver was negligent in operating a motor vehicle while intoxicated with a blood alcohol content of 0.33. That's very high. Driving at an unreasonable rate of speed, failing to remain reasonably alert. And then when suing the tavern, the plaintiff raised the Dram Shop law and negligent supervision of staff, noting that the staff were aware that this particular individual was a habitual drunkard and served him past the point of intoxication on the night of the collision. The defendants raised affirmative defenses, and so the jury actually, the court granted the plaintiff's summary judgment motion against the defendant, the drunk person, because they said he was negligent and that negligence caused your injuries. That's proximate cause. There can't be any other cause, so you get summary judgment against the drunk guy. But with regard to the other defendant, the jury actually made the factual determination that the tavern did not sell alcohol to this driver. So maybe, the driver was carrying a bottle of vodka, or maybe like they didn't have the receipts or any kind of proof or any kind of witnesses to say that this guy was being served. And so the tavern got let out, but the drunk guy was on the hook for summary judgment. It doesn't say the amount here. It says 0, I guess, because it was 0 against the tavern. So that's an interesting case. But they had an expert. They had a toxicologist. And I see here, it looked like a very, very serious case. But unfortunately, because of that factual issue, it turned out to be a defense verdict. And here's the final case. This is an interesting case. This one involves medical malpractice. And it also happened in upstate New York. This one happened, I believe, in Orange County, which is a little bit, Rockland County, I'm sorry, Rockland. They're near each other, Rockland and Orange. They're upstate, but not too far up, maybe about an hour north of the city. So what happened here was a doctor was performing surgery, and the lady, she actually suffered quadriplegia after undergoing a multi-level cervical laminectomy and fusion performed by the defendant, a neurosurgeon, and assisted by other doctors. And there was one doctor did the preoperative anesthesia, and another doctor reviewed the post-operative CAT scans, and another doctor was a physiologist who performed neurophysical monitoring, and then 2 nurses provided post-operative care, and then another nurse practitioner treated the patient post-operatively for hypotension. So basically, the plaintiff claimed the defendants were negligent in their pre, intra, and post-operative care. Pre is before the surgery, intra is during, and post is after the surgery. Plaintiff Jones, that was her name, she contended that the defendant doctor negligently performed the surgery by failing to obtain her informed consent, that the neurosurgeons failed to appreciate, recognize, and act upon a radiologist's post-operative report of an epidural hematoma, failed to send her for an MRI, and failed to perform exploratory surgery and additional laminectomies after realizing that she was paralyzed. So I guess this epidural hematoma was like a warning factor. Hey, she could become paralyzed. Let's do an additional corrective surgery, but for whatever reason, they didn't do it. And then it led to quadriplegia, to permanent paralysis. And Jones also contended that the non-party nurse was negligent for failing to recognize paralysis post-op while treating her for hypotension. And the defendants denied everything. They said these injuries were unforeseeable and unpreventable. Like, we could not have prevented it, and we could not even have foreseen that this could happen. And so at trial, the jurors found the defendant doctor negligent for informed consent. They assigned percentages at fault, like 30%, I think, to one nurse, and 25 to the doctor, and 25 to another doctor. Well, the percentages aren't that important, but the amount that they allowed for was very high. Compensatory pain and suffering was $20 million. Future medical was $420,000. Past wages were $800,000. Future wages were $79,000. And other compensations were $1.1 million. So the total compensatory award was $22,400,000. And then there was a loss of services, loss of consortium claim for $10 million more. So the total amount was $32 million. So it's a very high case, especially for Rockland, which is a very conservative jurisdiction. So an excellent result, $32 million. So that was spinal fusion, but more of a medical malpractice. Okay, I hope this has been helpful. We went through a bunch of cases. Let us know what other questions you have. Maybe we could do a few more cases. I'll read through this. It's 400 pages of information, and I'll pull out the most interesting cases, both defense verdicts as well as plaintiff's verdicts, and we could talk about some more cases. I think it might also be helpful to break them up because, you know, medical malpractice is one type of case. So maybe we could do a video just about medical malpractice with respect to spinal fusions. Then you have cases that are more like general cases that include all types of spinal fusions, whether it's something specific where you get a really high amount, like some of these cases for over $10 million, or whether it's just a regular case where somebody gets, like, I don't know, 500,000 or, you know, even 200,000, or even like 1 or 2 million, which is more like the average type of spinal fusion case. So we could do videos about each category, or we could just kind of pick and choose interesting cases. But there's definitely a plethora of cases out there to examine. So that's good. Okay, everyone, have a great day. Let us know what questions you have. We're here for you. Please like and subscribe to our channel and interact with us. And we'll keep doing the last week tonight where we answer your questions. Okay, have a great day, everyone. Bye-bye.